Danielle Pinnell and William J. for the state.
Oh, it's just my dad.
Thank you. Mr. Sterns requested to be transported this morning.
He was, Judge, he's in the room.
All right, thanks. Mr. Sterns. All right, we are here on 3 preliminary trial matters. These hearings are scheduled for 1 hour. Ms. Smith, I don't have a preference on what order we handle your motions. Would you like to address first? Question. Mr. Johnson, my apologies.
No problem. Tagging on the first motion, Alex Johnson for the defense. We'd like to address defendant's motion to remove newspapers from courthouse during pendency proceedings.
All right, thank you.
As to argument for this motion, defense did have pre-marked this morning, and I would move it into evidence as defense exhibit 1. It's been pre-marked as defense exhibit A. A copy of the Osceola News Gazette that was present in the lobby this morning, which directly addresses the Stephan Sterns trial to begin July 22nd on the front page of the newspaper above the fold.
State has no position, Your Honor.
Thanks. We received a defense 1 for purposes of this hearing.
So, as to this motion, with the recent denial of the motion to continue, the trial is set to begin next week in this courtroom. And as jurors, potential jurors and jurors that are selected in the trial walk into the courthouse, right in front of security or right beyond security is a slew of newspapers, including newspapers like the Osceola News Gazette, which every time we've had court appearance, Stephan Sterns has appeared on the front page of the newspaper. And the newspapers constantly indicate that there's both a sex case that is currently pending, which is what we're here for this morning, as well as a capital murder case. So defense is requesting that just during the pendency of the trial, not ongoing standing order going forward, that we remove these papers so that way the jurors are potentially as they come in and go about the courthouse.
All right, the state takes no position. I have confirmed with jury services that jury services do not provide newspapers to potential jurors. Court always has to be careful balancing the right to free press and the right to open and fair jury trials. I do find that should there be newspapers available where the jurors, can you give me some guidance as to where this table is downstairs? Is it over by the employee area? Is it where the general public would come in?
It's where the general public comes in. It's so if you're looking at the first floor, there's the area where you go to the elevators, and then there's the mirror there.
Yes.
It's the table's right in front of that.
Under
Security
the
glass.
progress screens.
Yeah, exactly.
I have inquired as to our court administration who provides the newspapers. I think that's a county function. We have proactively reached out to the county to see if we could suspend the delivery of newspapers during the jury selection process and throughout the trial. So your motion is preliminarily granted. The court will direct the parties that provide the newspapers not to do so during the jury selection or trial process.
Thank you.
Smith?
Yes, Judge. Defense would next like to proceed on the defense's motion to order all media to adhere to the rules of judicial administration and administrative order. Essentially, Judge, defense is asking, according to, as the rules require, that the media, and since defense is on the left side of this courtroom and the media is positioned directly behind us, their cameras intentionally, inadvertently, I'm not saying that they're doing it intentionally, is focused So in positioning, counsel's computer screens are in view of the media. So defense is requesting that the media not be allowed to look at, zoom in on, or otherwise project essentially onto counsel's table because of work product and attorney-client confidentiality. I understand that attorney-client confidentiality, we have to essentially affirmatively attempt to protect it. And when we have communications, we do mute the mic. However, because the table is so large and spacing, defense is just asking that the media not be ordered, not be allowed to zoom in on our computers or our computer screens. Under the administrative order, it says that communications between attorneys and their clients, between counsel and co-counsel, or anything that's held at the bench is required not to be recorded or broadcasted. So defense's position that anything that is occurring essentially at counsel's table in terms of notes, whether that be handwritten notes or computer screen notes, not be looked at. Defense has taken affirmative steps to have a privacy screen and additionally dimming the lighting on the laptops. However, even with that, it still is viewable for the media, and sitting in court with dim screens and dark lights for multiple hours is going to cause headaches, but also to protect not only Mr. Sterns' confidentiality, but potential other clients' information who we're working on while here in court. This is just the media not being allowed to look at or zoom in on computers or counsel's activities.
Your Honor, the state doesn't have a position. However, I think if the court is going to issue an order, it needs to be to everybody in the courtroom, not just specifically media personnel.
Are you saying to the state as well, in terms of media personnel, or anyone not being able to look?
There's a lot of amateur media people that will cover this trial, and they use phones, from my experience in other high-profile trials. So the order should be broad enough that it covers everybody in the courtroom, perhaps even an order that people in the gallery should not be allowed to have their phones out during the trial. Yeah. Sometimes they need daily reminders, sometimes they need multiple daily reminders, but they also focus on the state's computer, and we are obviously against that for the same reasons.
All right, our relationship with the media has been a good one. They're an essential community partner, and as I said, the court's going to strive to ensure that this is both an open trial and a fair trial. The days of passing notes back and forth are behind us. A little experience working with each of the attorneys here. I know that your coordination with witnesses, with each other, with presentation, with evidence is highly computerized. The court will expect that the media will comply with Florida Rule of Judicial Administration 2.450, as well as our Administrative Order 2023-23. That order is fairly specific. Under subsection 2E indicates that representatives may not cover sidebar or bench conferences, no recordings of conferences or information that occurs between attorneys and their clients, between co-counsel, between counsel and the presiding judge, held at the bench. I've done several trials where the media was involved. The only violations of 2.450 in our administrative order, in my opinion, have been inadvertent. Issues were when a camera operator perhaps went to a wide shot that included faces of the jurors during the trial, or there was a microphone that was inadvertently picking up communications through the microphones at counsel table after the microphones had been apparently muted by the attorneys. These are technical issues. We have a technical team here that the media is absolutely welcome to coordinate with. The administrative rule gives the media an opportunity to meet with our court administration if they have any questions about what the court's expectations will be. The court will expect that the media representatives will be credentialed pursuant to the rule. Non-credentialed members will not be permitted to have out cell phones as members of the general public. So I see no issue with the defense's request to have the media comply with the rules that are already in place, and the motion is granted. If representatives of the media have specific questions, they may contact my office. I will direct them to our court administration personnel. We'll provide a copy of the administrative rule, which I'm sure they are most familiar, and judicial rule, Florida rule of judicial administration 2.4. So the court will expect that that will be scrupulously followed in an effort not to impede the fairness of these proceedings.
And then the last one, obviously, the next motion to be free from physical restraints or utilization of normal or active use.
Thank you. State, do you anticipate presenting any witnesses in support of restraints?
The state just has one witness.
All right, thank you. I'm ready.
Deputy Richard Rosario.
Thank you.
Solemnly swear or
I do.
Good morning. Will you spell your first and last name for the record?
Yes, Ricardo, R-I-C-A-R-D-O. Last name is Rosario, R-O-S-A-R-I-O.
How long have you been employed as a court deputy?
Since March of 2017.
And is your primary assignment to this courtroom that we're actually in right now?
Yes.
Are there policies in place for the use of any type of restraints during a felony criminal trial for an accused?
That's correct.
And how many felony criminal trials have you participated in as a court deputy?
Numerous countless, I can't remember how many
That's fair.
I've worked.
What type of devices or restraints are available that would be out of the view of members of the jury?
So each courtroom has two, one device is kept downstairs in the first floor, which is a stun cuff. And in the courtrooms, we have a leg brace.
How is a leg brace utilized by court deputies during the pendency of a criminal trial?
So a leg brace is essentially a long bar. It has 4 straps. And in the center, there's a tab that you can pull so the person can sit down. Otherwise, the bar won't bend. So basically what happens is when the person sits, it bends, but when they stand up, it just locks. Prevents a person to run away. Well, they would have to essentially hop away because that leg is stiff.
What is the purpose? Let me ask you this. Are there any safety concerns for you as a court deputy in this courtroom should a accused during the criminal trial not be equipped with such a thing as a leg brace?
That's correct. So when any inmate is brought over to the courthouse, they're in restraints, handcuffs, and leg chains. When they're brought over for a trial, they are dressed out in proper attire, suit. And at that point, they're in the custody of the sheriff's office, and we have to maintain a level of safety and security for the inmate and as well for everybody else in the courtroom. So that's the reason why we utilize those restraints.
Is there limited staff here at the courthouse for the sheriff's office?
Yeah, so in a perfect day, the felony courtrooms will have 3 deputies. A misdemeanor courtroom would have 2, and civil would have 1. But due to staffing, sometimes people take off or they're sick, and it creates a safety hazard if we're running a high-profile felony case with just 2 deputies. So hence the reason why we use also the device.
Is this device something that is visible to anybody that is looking at the outer appearance of an inmate that's wearing it?
No.
Is this device something that delivers a shock or pulse of electricity or anything like that?
That's correct.
It does or it does not?
It does.
It does. When does that happen?
So if I may, I have the device in front of me.
Would utilizing the device assist you in explaining how it operates?
Yes, ma'am.
Go ahead.
So essentially, this is a stun cuff that's wrapped around a inmate's ankle and is tucked away under the clothing. There are 2 metal pieces here that is close to the subject's skin, and the strap is placed accordingly and wrapped not tightly but snug that it won't fall off. The remote is this right here, which is kept at all times with a deputy within the courtroom. Nobody knows who has it. So to activate this cuff, it's a 2-step process. There's on, and then there's fire. So the device won't accidentally fire on itself. It has to have a 2-step button to fire the device.
And the device isn't triggered by movements of an individual or anything like that? Advised by court staff in addition to the leg brace that you described?
It's one or the other.
So there's 2 options that are potentially available to court deputies depending on the scenario.
Correct.
And both of these options are outside the view of anybody that is looking at the outer appearance of an individual as long as they're wearing pants.
Correct. So when we put these devices on the inmate that's scheduled for trial, it's out of the view of the public, it's out of the view of the jurors. No one knows that the person set for trial has it on.
And let's talk a little bit about writing utensils. If there is an inmate present in court, are they given a writing utensil?
Yes, they do. They get a flexible pen.
And those flexible pens are made available by court staff to individuals that are participating in the criminal trial process?
Yes.
And what is the purpose of court deputies providing that specific type of writing utensil?
Essentially, the pen, it does write well, but is used sort of for a safety purpose in the event that the inmate would like to use it sort of as a weapon. The pen is designed to fold and flex as opposed to another pen or a big pen or a metal pen that can actually be used as a more deadly device.
It's a safety concern for court deputies?
Yes.
Can I just have a moment?
Of course.
For the purposes of this trial next week, what is the type of restraint that court staff deemed is appropriate for this case?
We will be utilizing the stun cuff, and actually this is a newer version. The older version is a much bigger, broader box. This one is a newer one, so we'll be using this one right here.
Thank you. Defense?
Good morning, deputies.
Good morning.
Now, you talked about the number of deputy or court personnel typically kind of staffed in the courtroom. Are you aware of what arrangements, if any, have been made in terms of staffing for this trial?
None yet.
So you don't know how many deputies potentially would be or won't be in the courtroom?
That's a question above my pay grade. I just will have to figure that one out.
Understood. Now, you talked about two different devices, and you indicated the stun cuff is the intention in this case, correct?
Yes, ma'am.
And is that because that's generally what's used in this courtroom, or because of what?
99.99% of the time, we always use a stun cuff.
So I want to talk a little bit about the leg brace, since you did talk about that. Now, this leg brace, this is a longer device. Like it's not as small as the stun cuff, correct?
Right. It's essentially a metal bar. It's pretty long, and it has 4 straps.
And to your knowledge, is that comfortable or uncomfortable?
I would say rather a bit more cumbersome because it's strapped alongside the leg of the person, and if they stretch their leg, it'll snap shut.
So essentially, normal movements could cause it to lock up.
Yeah, as soon as the person stands up, it will lock.
And then the stun cuff, I know you talked about this being a smaller apparatus that goes typically closer to the ankle, correct?
Correct.
And depending on the type of pants or clothing that is worn by the person, that could affect the visibility of the item.
Yes. So normally, male inmates will always have long pants, and the cuffs go right around it, so you really can't see it.
But the pants legs would have to be wide enough to kind of flow and fall over so it wouldn't be visible, correct?
Yes, and we always apply to the right leg, which is furthest away from the jurors.
And typically when sitting down, your pants often rise, generally speaking, correct?
Yes.
And so if the pants are shorter, then the stun cuff at that point would be visible likely?
Possibly.
And those straps, I know we saw kind of like the strap that goes around. Where does the extra, so to speak, of that tuck in, or does it tuck in somewhere?
So when you apply this apparatus, it wraps around, and then the strap goes through here, so it holds it down.
Okay. So similar to a belt, you know how when you use a belt and you have the extra, where would you tuck in, or where does that extra strap go?
It just remains there, and it just folds in.
So would it be secured, or would it be kind of sticking out?
Just stick it out wherever you would really have to look for it to find it.
Okay. Now, you talked about the 2-step process with that remote for the stun cuff. I believe you said it was an on and a fire, correct? So does that mean that once the stun cuff is applied, it's typically automatically in that on position, and then you just have to go to step 2, or something else?
Well, the apparatus is turned on, so it's always going to be on. But to fire it, you have to press the on button again, and then press fire.
Okay. And those 2 buttons are, I don't want to assume, are they next to each other on the remote? Or are they 2 different areas of the remote?
Yeah. So the on, and then you would have to switch over to fire.
So one side is on and one side is fire?
Right.
And I believe you said that typically one deputy has it, maybe between the 3 of you or 2 of you, depending on how many are in here, you guys would know, but none of the other court
Nobody
personnel.
knows who has it.
Just the person who has it, I assume?
Yes.
So you would know that you don't have it, and so if there's only 2 of you, by process of elimination, the other person would have it.
Correct. So essentially, when we do a courtroom operation, each deputy has an assignment. One is for the inmate, one is for the jurors, and